Hello, this is Graham. In this video, we're going to be looking at the legal considerations in counselling and psychotherapy. The first thing to say is that the number of cases of counsellors having to engage with the law is very, very small. Often issues are addressed by the ethics code and procedures of the professional body, and many issues are the result of the counsellor doing something that they knew was not a good idea. For example, getting into a relationship with a client. Claims can be made, though, against counsellors for all sorts of things, even things like tripping on a carpet, rather than professional errors. The law is very different from counselling. The law is linear, it tends to be relatively black and white, whereas counselling evolves, it's changing all the time. It's developmental, it changes with the nature of the client. It's imprecise, and it draws on lots of different influences. Ethics often involves making decisions, and when we make an ethical decision in counselling, we tend to be considering our own personal morality, the theoretical understanding that underpins what we've been trained in, our organisational policies and procedures, the ethical framework for counselling and psychotherapy from our professional body, and the law. And it's the law that we're going to be focusing on in the rest of this presentation. First though, just a quick reminder. The ethical guidelines that are produced by the various professional bodies are very definitely written to help guide the counsellor so that they don't fall foul of the law, and to protect them if they do. Because we are aiming to become a profession, we specify standards of behaviour that are often beyond those expected of the person in the street. Probably the area that most counsellors will think of when they're considering the law is the area of confidentiality. Ethical guidelines make it very clear that the therapist has a duty of confidentiality, and this is much more than is expected of a member of the public. The law says that there are some situations where we must break confidentiality. Let's have a look at some of those. There are 3 situations where the law requires us to breach confidentiality. The law concerned is largely the Terrorism Act from 2000, the Money Laundering Regulations from 2007, the Money Laundering, Terrorist Financing and Transfer of Funds Regulation from 2017, and the Drug Trafficking Act of 1994. You have to be really sensible about this. This is not trivial things. This is when a client openly admits that they have been involved in some kind of activity that you would have to judge was illegal. The 3 situations in which we are required to breach confidentiality are when a client discloses information about money laundering offences, in which case they must be reported to the police, when a client discloses information about an act of terrorism or drug trafficking, and in this case we have to report the information and must not tell the client that we are doing so. And then finally, when a judge or coroner makes a legal order for the release of our client notes. When we start working with a client, we are in a commercial arrangement, certainly if we're in private practice. Failure to deliver on that contract means that they can sue you for breaching it. Contracts don't have to be written, but it's a lot easier to defend yourself if they are, which is why most therapists will have a standard pro forma contract that they ask their client to read through and sign. Contracts have to provide basic information, and you can find out what that is by searching on the internet. I've put a link on the bottom of this slide where you can follow up on one particular example of this. Contracts provide proof, they prevent misunderstandings, they give security and peace of mind, they reduce the risk of disputes, and they set out how they can be resolved if a dispute does occur, as well as explaining how to end the contract. For it to be a contract, both parties must receive something of value, a consideration. Otherwise, it's a gift rather than a contract. Your client is receiving your services. You are receiving payment. It's largely because of the potential problems of contracts that most therapists choose to take out insurance, though actually most professional bodies require it. These days, most risks are covered by one specialist policy. This covers what's known as professional indemnity, which means public liability, products liability, libel, and slander. It also covers you for the costs of defence against claims of professional negligence, breach of confidentiality, and physical or emotional injury. If a claim is successful, then your insurance will pay out the compensation to the victim. Equally, if the claim is unsuccessful, many insurance policies will pay you for your loss of earnings in the process of defending yourself. And finally, if you specify it, certain policies will also include the costs that are involved in responding to HMRC, that's the Revenue and Customs or tax inspectors, investigations. I'm sure we've all heard of the GDPR, the General Data Protection Regulations, which is an EU law that provides 8 rights to individuals. When Britain leaves the EU, its own legislation, the Data Protection Act from 2018, is expected to continue to provide these. They are the right to be informed, to have access to your records, to rectify faults with them, to erase them if necessary, to restrict the processing of the data, to restrict the portability of the data, to object if you feel that data has not been adequately safeguarded, and also provide you with some rights in relation to automatic decision making and the use of the data for profiling purposes. There's loads of advice online, including through the BACP, and some people will be much more rigorous in complying with this than others. In essence, data protection means that you have to keep basic factual records, and you should do so securely. You should destroy them securely when they're no longer needed. Client notes will certainly generally be kept for 3 to 4 years in case the client wishes to claim against you. But invoices, which should be kept separate from the client notes, will usually be kept for longer so that the HMRC can check your tax liability. You probably also do need to register with the Information Commissioner's Office. It would be very interesting to know how many psychotherapists and counsellors actually are, even though the fee is somewhere in the region of £40 per annum. Another simple legal issue which is worth recording is that of statutory regulation. There is no legally enforced regulation of counselling and psychotherapy in the UK. That is not the case in other countries. By joining a professional body and adhering to an ethical code, you are doing so voluntarily. The titles of counsellor and psychotherapist are not protected. Anybody can claim to be one or the other. There is no legal minimum qualification needed to practice, though most employers nowadays will require a minimum qualification of level 4 diploma in counselling. We have to recognise that the decision to introduce statutory legislation is being very hotly debated. It'll probably take a long time to happen, but it will probably eventually do so.